arises, and this is an enabling provision. Mostly what happens is here there is either a defect due to a clerical mistake. Sometimes what happens is instead of Mr. comes, instead of Miss Srimati comes, so on and so forth. Or the schedule of property misdescription is given. Schedule is not properly given. Then in that case, whenever an arithmetical or let us say a clerical error takes place, either party to the document can apply for rectification. Easiest form of rectifying a document is by having a bilateral document and getting it registered. But please remember, once a document is executed, the vendor loses the interest as far as that document is concerned. After all, you are going to be the sufferer because you have paid the money, you have got the document registered, everything. So in that case, what happens is you can always file a case under section 26 of the Specific Relief Act for rectification of that instrument. Wherever the mistake has occurred, you can ask that mistake to be corrected. Please, one fundamental rule you must remember is only a party to the document can apply for rectification. A stranger cannot apply for rectification. Here, as far as the court fee aspect is concerned, section 43 of the Court Fees Act, that is our corresponding act here in Telangana, the court fee that is liable to be paid is only 15 rupees for rectification. It's the most cheapest remedy that is provided. But in a rectification suit, what all you have to plead is, you will have to say what the document speaks, where the error has occurred, what is the thing you want to get it corrected, and you also file a corrected form of the document, and then accordingly the court, after hearing you, passes an order rectifying the instrument. But please bear one thing in mind, that whenever you file a suit for rectification, we must also make the sub-registrar a party. Why? Because once rectification or correction is done, a copy of the decree should be sent to the sub-registrar to make the necessary entries in his books. Are you able to follow, please? Here, one thing I would try to say in a very humorous way, that once a child goes to his father to get his report signed, what he does is, to mislead his father, he makes 3 into 8, 8 into 9, 9 into 10, alters the figures. The father is very happy that my son has got so many marks. But if you see the official record, it will be something different. Here also, I'm trying to tell you that if there is a defect in the instrument, file a suit for rectification under section 26. It's the easiest remedy that is possible, and it's an enabling provision. And rectification also can occur when there is a fraud, there is a mistake, and there is a clerical or arithmetical error which has occurred. You can get it corrected. But when you file a plea, you must file the copy of the original parent document and also the corrected copy which you want the court to correct. And also make the sub-registrar also a party to the proceeding, so that a copy of the decree can be sent to the sub-registrar to make the necessary corrections in his records. It may be the sub-registrar, it may be the MRO also, because revenue lands, especially, it's registered by the MRO normally. Here in Telangana, when the Dharani came, the sub-registrar never registered it. It's only the MRO who registered the document. Earlier procedure was, when you present a document for registration, the sub-registrar no doubt accepts the document, but sends it to the revenue authorities to make the necessary search and find out whether such land exists or such extent exists, or whether it is in a particular thing or not. Then it is done so. And please remember, along with the earlier, the procedure was, when you present a document to the sub-registrar, as far as landed property is concerned or agricultural land is concerned, you have also to submit the passbooks also, because suppose you are holding 100 acres. Out of 100 acres, 10 acres is sold. What the MRO does is, sir, this total extent is 100 acres and the transaction is 10 acres, still only 90 acres remain. 10 acres has already gone. That was the earlier procedure. But now in Telangana, after the Dharani had come, it has given reason to a lot of problems. I think less we talk about the revenue authorities is better. Here, a donkey is made into a horse, horse is made into a donkey. Sometimes what happens is, Vajravelu అని పేరు ఉంటే రుద్రవేలు ఎంట్రీ చేస్తారు మాట. రుద్రవేలు ఎవడున్నాడు కూడా తెలియదు. The question is, sometimes what happens is fictitious entries take place, because this is because of fraud, this is because of mistake, This is because of so many reasons. So to prevent such abuse being done, Section 26 has been provided where you can get the entries rectified or corrected. This is what Section 26 speaks about. So it's a very, very small section. But I told you also, when you read a section, you will have to read it in an objective way and not in a subjective way. What do you mean by objective way? Try to understand the meaning of every word used in the section. Try to know the meaning. Then, like an orthopedic surgeon, join all of them and then understand the meaning. Please remember that's the easiest way of understanding a section. When we were in college, we were never taught that a section has to be read or understood in an objective way. Just only thing is from the first word to the last word, blah, 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 the section is over. Every enactment or every section, rather I put it that way, contains explanations, contains exceptions, contains illustrations also. If you still want to understand it in a better way, read the illustration first and then come to the section, so that you know the purport of the section. So this is what I omitted yesterday. I wanted to cover it, sir. This is Section 26. Then the next one which we discussed was rescission of contract. That is Section 27 and 28. Here, rescission. What do you exactly mean by rescission? The dictionary meaning of the word rescission is, rescission comes from the word resigned, avoid, retract, revoke. There are four meanings that can be given to the word rescission. Rescission comes from the word resigned. Resigned means avoid, retract, revoke, or take it back. That is what is called rescission of contract. Here, any contract which is where you want to avoid a contract, you don't resign from the contract, you don't want to perform your obligations under the contract, a remedy lies to you. As far as Section 27 and 28 is concerned, you can file a suit for rescission of contract. But one thing is this, it is founded on equity. One who seeks equity must do equity. In English, they say, you cannot have the cake and eat it too. If you want to eat the cake, suppose there are thorns in that, thorns you have to remove it. No one says, please take it along with the thorns. Thorns, you remove it and then take it. Sometimes a contract is made in such a way, good things are there, bad things are also there. Some of you who have been students of Constitution know shaffing the grain. What do you mean by shaffing the grain? I think mostly ladies know it better. Chart తీసుకొని ఆ రాళ్ళు ఏదైనా ఉంటే రాళ్ళు ఏరుకొని ఓన్లీ ఇది రైస్ మాత్రం తీసుకుంది. అలాగే suppose a contract contains two parts, the malignant part as well as the proper part, and the contract is voidable, let us say, because of the vitiating elements being present. Then in that case, suppose the entire contract is taken, good part of it can remain when the bad part is removed. Then the good part is allowed to remain, the bad part is removed. I'll give you one explanation, sir. Here, suppose, let us say, A makes a contract with B, saying that he will sell 150 acres of land, 100 acres belongs to him, and 50 acres does not belong to him, it belongs to his sister. Please remember, I think you know the maxim, name out that quod non habet, no man can pass a better title than what he himself has. As far as 100 acres are concerned, you are not bothered about it because it is within his disposing capacity. As far as the 50 acres is concerned, he cannot sell it unless he takes the consent of the real person who is the owner of that property. It visualizes the situation. The court instead of allowing rescission, it can say to the extent of 100 acres, the contract remains valid. As far as 50 acres is concerned, it is void because it is not within the disposing capacity of an individual, so he can resign from the contract. Sometimes it so happens the person receives the entire consideration for 150 acres, promises you that you get the clearance from the rightful owner. He is not able to get it. Then in that case, suppose the entire consideration is paid, court what it does is, it passes an order when resigning the contract to pay back the money for the 50 acres which has been collected, plus the interest part of it and the damages also in some instances. So one who seeks equity must do equity. The second equitable principle. That means, suppose you want to avoid a contract, you want to resign a contract, you must also be prepared to suffer the detriment also. That is, whatever monies you have received under that void or voidable contract, you have to restore it back to the opposite side. That is the exact meaning of rescission. Am I making myself clear to you, please? But one thing is important is that suppose, let us say, the bad part of it is removed, good part also cannot remain. Then in that case, the entire contract has to go. Contract will be resigned. So rescission is normally permitted only in exceptional circumstances, not as a matter of rule. Then, where here, mostly, I think most of you are civil lawyers also know that if you file a suit for specific performance, court decrees the suit in your favor. Balance of the sale consideration has to be paid, isn't it? Then the court says within 3 months, the balance of the sale consideration has to be deposited or paid to the opposite side, and then the document will be registered. Suppose, let us say, you don't deposit that money within the 3 months period or 6 months period, as the court grants, you are not entitled for specific. I mean, making myself clear to you, please. Suppose the court puts a rider saying that no doubt you are entitled for specific performance, but you must deposit the balance of the sale consideration within 3 months. If you don't deposit it within 3 months, the decree gets wiped out. So, but one thing is this, please remember, Manako, Abraham Lincoln says, for everything we find an exception. You can always file an application, sir, I am arranging for money. It's not possible for me to arrange within short span of 3 months. Please extend the time for 3 more months so that I can arrange for the money. Then the court normally is very, very sympathetic and extends the time for 3 months, and then you deposit the money. Even after that, you don't deposit. Please remember, no one can help you. The decree gets wiped out. Then one more instance I can give you is, mostly you know, there is a suit called mortgage suits under Article 34 CPC, where it says installment decree cannot be granted as far as a mortgage is concerned. Only thing is, equity of redemption can be granted. What do you mean by equity of redemption? That means whatever is due and payable by the debtor to the creditor or the bank or the financial institution, along with interest and cost, will have to be paid or deposited into the court. Then the court directs the opposite side, that is a creditor, to return back all the documents duly cancelled, and then the property gets restored. But here, let us say, please remember one cardinal rule you remember, no installment decree can be passed in a mortgage suit. This is the most important thing we must remember. There is no installment in mortgage. But equity of redemption is granted. Equity of redemption is, I'll just give you a mythological example where the Lord Narasimha, while vanquishing the demon king Hiranyakashipu, he bodily lifted the body, took him, he pierced the stomach, pierced the chest, and tried to tasted the blood of Hiranyakashipu and tried to find out whether any bhakti is still left in him. When he felt that no bhakti was left in him, then he killed him. In the same way, here also the court is not interested to see that you lose your rights in the property. That's why equity of redemption is granted. You are given 3 months' time or 6 months' time, before which you must deposit the money into court. Once you deposit the money into court, automatically the court directs the opposite side to return back all the documents duly cancelled. Suppose the court grants you 3 months' time. You don't pay the money within 3 months. You don't ask for extension also. Then in that case, the creditor can proceed with the sale of the property. So maximum time is, I'm not for a moment saying a mortgage suit ends with the lower court. Please remember, even if it wants to end here, our advocates will not allow the party to end the litigation. Why? Because long live litigation. That's how we advocates live. We file an appeal against it, then go in second appeal, then go to the Supreme Court. Then afterwards, ultimately you have to come to the lower court only. So the question is, as far as possible, like poison, the interest goes on creeping. So the reason is, if an equity of redemption is granted, within that time, you must try to deposit that money. If you don't deposit the money within that time, or the extended time which the court grants you, then in that case, you cannot get back the property. These are all the exceptions which you have to keep it in mind. Then you got, of course, now I think reconveyance is not there. Earlier, what used to happen is, mortgage deed is executed. I think you know the definition of mortgage. Mortgage means where an interest in specific immovable property is created for the purpose of securing a loan, paid promise, part paid or part promise. It is called a mortgage. మనం తెలుగులో వచ్చి తనఖ అంటాం. ఇక్కడ ఏజెన్సీ ఏరియా అంటే వర్డ్ దట్ ఈస్ యూస్డ్ ఇస్ తనఖ. బట్ హియర్ ఇన్ తెలంగాణ ఇట్స్ హాఫ్ తెలుగు అండ్ హాఫ్ ఉర్దూ. అన్నిటికీ గిరివి గిరివి అంటారు. గిరివి అనేది మార్గేజ్, రెహెన్ అంటే ప్లెడ్జ్. సో బట్ హియర్ as far as Telugu is concerned, the word tanaka is important. Here, along with that, an agreement of reconveyance also is executed, whereby the agreement of reconveyance says the property is offered as security. Once you pay back that money within a period of 3 years, your property will be reconveyed back to you and I will execute a sale deed in your favor. That is sale deed in favor of the debtor. Suppose that period expires, no one can help you. So an agreement of reconveyance also has to be properly adhered to. In this regard, I would cite AR 1961, Supreme Court. Can kindly note, please. AR 1961, Supreme Court 882, which speaks about this in detail. Here, I gave you the significance of an alternate prayer also. Here, if specific performance cannot be granted for any reason whatsoever, then there must be an alternate prayer also to say for refund of a sum of rupees, whatever is been paid as advance to the opposite side while making the agreement. Here, according to the judgments here in Telangana, unless you plead that in your plaint, alternatively, for refund of the money, court is not bound to grant you that money. Court will not grant that money. But earlier, please, punyamo purusharthamo unde. In equity that used to be returned. But now there must be a specific prayer in your plaint asking for alternate relief. Alternate relief is compulsory as far as suits for specific performance is concerned. Am I making myself clear to you, please? Alternative relief means the inequity, whatever money you are entitled to get back, that has to be clearly pleaded. Please remember, again, I take you back to Order 6, Rule 2. It says plead and then prove, not prove and then plead. Unless there is a pleading, there cannot be a proof. So alternatively also, you have to claim for refund of the money, whatever has been paid. Then one more instance arises. Normally in the agreement of sale, we advocates what we do is, in case the amount is not, the balance of the sale consideration is not paid within the stipulated date, then the advance and earnest money shall stand forfeited. We use the word forfeited. Please remember, law leans against for forfeiture. Suppose the contract fails for any reason, whatever monies are had and received, they have to be restored back to the opposite side, because according to the principle of unjust enrichment, that means you cannot eat the money of the other side and use the forfeiture clause in order to make a wrongful gain. That is the reason why alternate prayer plays a very important part. You must also ask for refund of the money, whatever has been paid. Unless you ask for that, court will not grant you refund. Yes? Then, yesterday, I was dealing with cancellation of instruments. That is 31 to 33. What do you exactly mean by cancellation? Ante cancellation ante Telugulo correct word is raddu cheyadam. That is what is called cancellation. Suppose and all suits here in cancellation, the word free consent plays a very important part. I think to put it in the legal language, consensus ad idem. Unless the consent is free, unless the consent is voluntary, unless the consent is given with full will and pleasure, the document is not admissible. Here, vitiating elements of contract are there. I think I discussed with it yesterday also. Section 15 to 22. 15 is coercion. వాడిని ఒకటి భయపడి చేసి ఒక పత్రం రాయించుకుంటే ప్రామిసరీ నోటో లేకపోతే అగ్రిమెంట్ ఆఫ్ సేల్ లేకపోతే సేల్ డీడో వాట్ ఎవర్ ఇట్ ఈస్, then if the document is allowed to remain, it is going to cause enormous prejudice to you, enormous loss to you, enormous damage to you. And in that case, you can say, sir, my consent that has been given is not a valid consent. It is voidable because it's vitiated by coercion. I have been put under threat. I have been put under threat of bodily fear, or injury to my body, injury to my property. That's the reason why I signed the document. Nani katti chupichesi document raskunnarandi, document raddu cheyavalsindani cheppi adugutaru meeru. That is what is called cancellation. But please remember, again, it is based on equity. That is, suppose let us say the document is voidable. You'll have to say what are the circumstances where the court can infer that it is vitiated by coercion. You must give the circumstances under which the document is invalid. And mostly the precaution which you advocates or we as advocates advise the parties to give a police complaint, and police does not take action because it's a civil dispute. Then we say, I've taken all precautions possible. Even in spite of that, the document has been taken from me. Please cancel this document because the consent is not free. Consent is vitiated by coercion. Then I also discussed yesterday, that is where there is a misrepresentation. Where, please remember, flow. ఈ పవర్ ఆఫ్ అటార్నీ వాళ్ళు ఉంటారు చూడండి, బాబు ఈ భూమి ఎక్కడ అంతా మనదే అనుకోండి అంటే దట్ మీన్స్ యూ సే దట్ ది ఎంటైర్ ల్యాండ్ బిలాంగ్స్ టు మీ లైక్ ద నిజాం సర్కార్. ప్లీజ్ రిమెంబర్, డోంట్ బి క్యారీడ్ అవే బై హిస్ వర్డ్. యూ ఓన్లీ ట్రై టు ఫైండ్ అవుట్ ఫ్రమ్ ద డాక్యుమెంట్స్ whether what is the plot you want to purchase, whether there's a proper layout, or whether you have been taken for a ride, or the misrepresentation has been made in order to induce you to enter into a contract. Then you say it is induced by misrepresentation. Then third one is fraud, where a person who makes a representation knows that it is false or makes it in such a way to induce another person to enter into a contract to deceive the opposite side. Then we say that the contract is vitiated by fraud. Then please remember, you can easily say fraud, but the ingredients of fraud in section 17 has to be clearly pleaded in a suit for cancellation. Am I making myself clear to you, please? So in incidents of fraud, in various instances through which the court can presume fraud has been committed, you have been cheated, you have been deceived, you have been made a victim of deceit by the opposite side, then in that case, and the document has to be cancelled, all things have to be clearly mentioned in the plaint. Just by making an allegation, the contract is vitiated by fraud, it will not suffice. You will have to mention the incidents which the court tries to infer that fraud has been played. And please bear one thing in mind, whenever fraud is played, the period of limitation does not start on the day when the fraud is played, but on the day when the fraud has been detected, discovered by you. And this has to be clearly pleaded in the plaint. What all you have to prove in a suit for cancellation is that the document is vitiated by any of the elements shown in section 15 to 22 of the Contracts Act, and the consent is not free, and you are entitled to get the document cancelled. And if the document is allowed to remain, it is going to cause enormous loss to you. Then in that case, in proper cases, the court grants you the relief of cancellation, where the document is duly cancelled. It has no legal effect at all. Here also, you try to make the sub-registrar a party because there is a written document, there is a written instrument, sale deed, gift deed, whatever it may be. Then the registrar also has to make the necessary entries in his books. That is the reason why the SRO or the sub-registrar is made a formal party in these type of suits. This also applies as far as cancellation of decrees are also concerned. Sometimes what happens is the party cleverly, a proper and necessary party whose rights are going to be affected, he is not made a party to the suit. Some other X, Y, or Z is made a party. Then in that case, who is going to be ultimately a loser? The actual owner of the property. Then he can say, sir, this document has been executed. This has been done by fraud. I have not been made a party to this instrument. Please try to cancel that document which has been fabricated or which has been created, which is null and void. Then in that case, the thing can be cancelled. Then mostly because of the land value is increasing, the vendors have come with a suit saying, sir, the consideration is no doubt mentioned in the document, but it has not been paid to me. Please remember, it's very, very difficult to understand that. I have also filed suits, but my conscience doesn't permit because no one signs a document without receiving the money. If you see the reverse of a instrument, the sub-registrar inquires, బాబు నీకు పూర్తి డబ్బులు ముట్టిందా, ఎలాగ ముట్టింది, చెక్ ఇచ్చాడా, డ్రాఫ్ట్ ఇచ్చాడా, లేకపోతే క్యాష్ ఇచ్చాడా అని వాడు ఎండార్స్మెంట్ రాసుకుంటారు అనమాట. The vendor hereby admits and acknowledges having received a sum of rupees to so and so towards the sale consideration. It's very, very difficult for us to go back on that. But some are instances where real consideration is not paid, but still people are taken for a ride. Then in that case, suppose you're a party to the document, a fraud has been played, a mistake has occurred, or let us say an instrument has been taken by any of the vitiating elements, then in that case, you can get the document duly cancelled. One more thing is, as far as court fee is concerned, you pay the entire court fee, whatever is the value of the document, the court fee has to be paid for the entire value. That is what Section 37 of the Court Fees Act says. Because here in Telangana, we don't have a separate act except for your AP, you call it as AP Court Fees Act. Here we call it a TSS CV Act. Now it's not TS, it's now TG CV Act. That means Telangana Court Fees Act. The entire consideration mentioned in the document has to be paid in a suit for cancellation. Please remember, when you are not a party to the document, a suit for cancellation does not lie. Then coming to the period of limitation, sir. So Article 58 and 59 of the Limitation Act says a suit for cancellation has to be filed within a period of 3 years from the date of the instrument. If you don't file it within 3 years, later on you cannot file it. That is Article 58 and 59. But except in cases of fraud, where fraud has been committed, there is no limitation. In some cases, what happens is, suppose the document has been brought about by fraud or so and so, the court has got power under Section 33 to award compensation also. Compensation also can be awarded. Then we go to, I think yesterday we were discussing relief of declaration, declaratory decrees, 34 and 35. Yeah, 34 and 35 deals with where a position, character, or a cadre, or anything is pleaded, anything is asserted, and it is denied by the opposite side, you can get that status, position, character declared by a competent civil court. And normally nowadays we have got mostly the civil litigation which is feeding most of the advocates are family court cases. The real problem arises when a person dies. His terminal benefits have to be paid. Please remember, excuse me, the Supreme Court has gone on record to say that you can have more than one marriage also, isn't it? In some of the cases they have said you can have two marriages also, though Hindu law practices monogamy, but still you can have a second wife. But once, I think yesterday I was giving you in a humorous way, Savitugora start out who has to get the appointment, who has to get the terminal benefits, who has to get the benefits, so on and so forth. Mostly on humanitarian grounds, when a person dies in service, a job is given to the dependent. The first wife says, I am the legally wedded wife. She is absolutely right, because under Hindu law, only monogamy is permissible. The second wife says, no, sir, the first wife has already been divorced. She is not the wife, I am the wife. Then the second wife goes, first wife goes to the court, asks for a declaration that she is the legally wedded wife of so-and-so, and second wife is only a mistress and she is not entitled to it. But please remember, all of us, unfortunately, what happens is, it's a male-dominated society. No one says, I'm the legally wedded husband. Everyone says, I'm the lawfully wedded wife, but not lawfully wedded husband. The question is, when a character is claimed, when a position is claimed, and that position is denied by the opposite side, you can always get a declaration, sir, you are entitled for that particular status. Then suppose retirement benefits are there or family pension is there, who is entitled for it? Both the wives fight for it. And once they succeed in the court declares them as being entitled for that particular relief. Please remember, a suit for declaration, a decree for declaration is a jus in rem. That is, it is operative as far as the entire world is concerned, but it is the only provision which is not executable under Order 21 Civil Procedure Code. Then sometimes it so happens, sir, I'll give you one more instance. Suppose, let us say, you file a suit for injunction, let us say. Then let us say the other side denies your title. Then in that case, what is imperative, sir? You must amend your plaint and ask for an additional relief of declaration and say, sir, I am the owner and possessor of so-and-so property, and the other side is by his pleadings as denied my title. Please try to declare me as the owner of the property and try to defeat the claim of the other side. And in that case, what the court does is, it permits you to amend the plaint, and you pay the extra court fee for it also. Court grants you not only not only injunction, but also declaration also. Or suppose here sometimes it so arises. There is one section 34(1), sir. Most of our advocates commit mistakes. Here in 34, declaration, to declare the plaintiff as the owner of the property. That's the first prayer you ask. But 34 proviso says when you ask for declaration, you must also ask for possession. If you don't ask for possession, declaration cannot be granted. Why? Because it will give rise to multifarious litigations later. In the same litigation, it has to be thrashed out. So if you don't claim possession and only ask for declaration, your suit is not maintainable under 34 proviso. Then we go to the most important chapter, which feeds most of our civil advocates. That is law of injunctions. Law of injunctions is called the prohibitory reliefs or preventive reliefs. Just like when we have fever, we have paracetamol, dolo, crocin, so on and so forth. Upasamanam kosam. Not that your fever is going to vanish. At least for that stage, you have some relief. Or let us say you are having a headache. You try to apply Amrutanjan, Zandu balm, so on and for this balm, that balm and all. Or nowadays, I think Shastri balm also has come. So so many things are there. But it doesn't give you a permanent relief. But temporarily you have a feeling in your body that something is working. I'll give you one instance where a naturopath gave a lecture in our High Court. Talking about naturopathy. He says, sir, whenever you have a headache, don't bother about it. First, try to wash your face with cold water and then lay still for 10 minutes. Automatically, the stress goes. You're relieved of the headache. Then, of course, acupuncture. And there is another way. Acupuncture people also say, these lobes are there, finger lobes. You press these lobes, automatically you get relieved of it. And he says that if you are having stomachache or if you are having stomach problems, then you try to consume cold water in the morning, at least one bottle of water, automatically everything gets relieved. He says, don't go for medicines, right? Of course, Baba Ramdev preached all those things, but he has got into trouble also, trying to criticize the other systems of medicine. Allopathy and all, it says, all ambak. My medicine is only superior. But of course, you are not supposed to do it. So here, injunctions. Injunctions is spelled in different way by different professionals. As far as the doctor is concerned, he knows only one thing called injunction, soothing. Injunction. Please remember, there's a distinction in the spelling. INJECTION is injunction. INJUNCTION is injunction. But most of the advocates, what they do is they say suit for permanent injunction. They don't use the word injunction. They don't look into the book, but they write injunction. Injunction is not given by an advocate. It is not your sphere of activity. You only know how to get an injunction. And most of the civil cases which are filed today are all injunction suits. Unfortunately, what is happening is courts are very, very reluctant to grant injunctions because they say they follow the principle of what is called adi alteram partam. Let no man be condemned unheard. That is, hear the other side before you pass an order. And one of our judges who became the Chief Justice of Madras High Court also, Justice Subhashan Reddy, said, "Yet order status quo istadu adi kojja order antadu. Mogaina gadu, adame gadu. Ye status quo. If you grant an injunction, grant an injunction. If you don't want to grant an injunction, don't grant an injunction." I still remember one of the junior advocates who just entered the portals of the courts said, sir, please, sir, injections. Then the judge said, sir, I'm not a person giving injections. I'm a person giving injunctions. You spell it properly, then you argue. Then, please, sir, this is my first case. You need not beg the court. You need not ask the court to grant you an injunction. Try to make your presentation properly, marshal your facts properly, marshal your documents properly, and then try to place out your case and try to plead your case in a proper way. Where, let us say, here I take you to equity. Here, earlier, common law courts never used to grant the relief of injunction. Suppose, let us say, an agreement is made. Sir, we don't make an agreement for fun's sake. both of us, be it the vendor, be it the offerer, or be it the acceptor. We want the agreement to be implemented or enforced in the letter as well as in the spirit. There shall not be any violation, there shall not be any breach, so on and so forth. We don't make an agreement for fun's sake. But common law courts used to say, sir, we are very, very sorry. We cannot issue a writ for injunction. We cannot prevent a wrong being done. If a civil wrong, please remember, breach of a contract is only a civil wrong, or what you call it as torts. You cannot enforce torts in a common law court. We will only grant you money compensation. Please wipe your tears, remove the glycerin from your eyes, take this money and walk out of that. And they never used to prevent a person from doing a wrongful act. Then equity stepped in and evolved this relief of injunction. What do you mean by injunction? Injunction means a prohibitive relief or a preventive relief which gives a right to a party to prevent a wrong being done, which is done, about to be done, apprehended to be done, in the process of being done. Then in that case, a suit for injunction would lie. Am I making myself clear, please? It's something like gagging your mouth by conduct by saying, you cannot go back on your contract, you cannot go back on your words, please don't do it. That's what the courts normally grant. Here, one thing is this, injunctions are of three types. One is called interim injunction, another is called temporary injunction, and another is called mandatory injunction. Section 37 to 36 to 39, 38 deals with injunctions. We'll go one by one. When we file a suit in a civil court, be it a junior court, senior court, or district court, whichever it may be, a suit is filed simply for injunction. Then you also move it with an out of order. Out of order means urgently to be heard in the afternoon. And then you make an interlocutory application also, requesting the court to grant you what is called an interim order of temporary injunction. Please remember, so long as CPC was not amended in 1976, yes? CPC was not amended in 1976. As soon as a suit for injunction is filed, automatically injunction used to be granted. But 1976 code, if you are carefully going through that, it says no interim order should be passed as a matter of right unless the other side is heard, unless the other side is given an opportunity of filing the counter and filing his defense and also filing the documents. Only after hearing the other side, an interim order can be passed. So to overcome that, what the courts are doing is, they are passing status quo orders. According to you, status quo is something else. According to me, status quo is something else. And status quo works yes, exactly. Status quo works havoc also. Please remember, status quo order these could because and you try to avoid the status quo order to be served on you. So there are various ways and means to avoid certain things, sir. But the question is, once what do you mean by interim injunction? Interim injunction is, court normally cannot grant an ex parte injunction unless after hearing the opposite side. Other side should be given an opportunity of filing his counter or filing the document. Only after hearing the other side, an interim injunction can be granted. So to avoid that, I told you that they pass a status quo order. And one more thing is this. An interim injunction is valid only for a specific duration of time. Suppose, let us say today we are on 2nd June, 3rd June you file the suit. Your court will grant you time till 5th, but grant you interim injunction till 5th. What is your duty as an advocate? Interim injunction works itself out on 5th. You must file a memo or you must file a petition asking for extension of the interim orders. If you don't ask for extension, automatically it works itself out. Then after that, the next stage is reached. Interim injunction is only for a limited duration of time. It should not be for more than 30 days. Then once the notice goes, once an interim injunction is granted, it is your duty to send the copies of the plain, copies of the material papers to the opposite side by registered post and file an affidavit of compliance. Affidavit of compliance under Order 39, Rule 3, saying that the document is by the postal receipt. So unless the compliance is made, injunction will not be communicated to the other side. Let us not go into that. Then after the notice goes to the other side comes to the court, files his counter, files his documents, and arguments are heard on both sides. And then the interim injunction, suppose the court is satisfied with you, it makes the injunction absolute, allows your petition for injunction. That means absolute means it will continue till the suit is disposed of. Am I making myself clear to you, please? So interim injunction is converted into temporary injunction. Then after that, I think you know the procedure. It is an appealable order under Order 43, read with section 104. So it is an appealable order. You can file a miscellaneous appeal before the district court or the high court, challenging the order of the lower court. Suppose the court is not satisfied with your petition or your document, court dismisses your application. That is, injunction is granted, it is vacated. Am I making myself clear? Interim injunction is granted only as a temporary measure. After that, once the other side is receives the notice, files the counter and files the documents, arguments are heard, interim injunction gets converted into temporary injunction. Then, next stage. After that, suppose evidences are led on both sides, issues are framed, evidences are led on both sides, the court passes a decree for perpetual injunction. That means for forever. So these are the three stages. Interim injunction is governed by the specific relief act. Temporary injunction is governed by the specific relief act. As far as temporary injunction and interim injunction also is concerned, it is covered by Order 39, Rule 1 and 2 CPC. Only what is covered by the specific relief act is perpetual injunction. That is under section 38. So, in a decree for perpetual injunction is passed after evidences are recorded, it is appealable under section 96, read with order 41 Civil Procedure Code. Then we come to what are the ingredients you have to satisfy for grant of injunction. One is a prima facie case. That is a case triable on merits. That is called a prima facie. On the face of it, if you have got a triable case. Second one is balance of convenience. That is, you are necessarily entitled for preventive relief, and unless that is done, the entire facts are in your favor, entire documents are in your favor. That is called balance of convenience. Third one is, if injunction is not granted, lot of hardship will be caused to you, and you will be put to a lot of misery and suffering. If these three ingredients are satisfied, the court is bound to grant you an injunction. There are various rulings on this particular aspect. Here, suppose, let us say, normally, sir, whenever a partition suit is filed, you also ask for injunction. Partition, when do you file for partition, sir? Suppose you belong to the same family, you want your share, and please remember here I try to give you an example. I think now women's rights has become absolute. I still remember I was the first person to give an article in the paper to say the Pandora's box of dowry deaths have been opened by introduction of 29A, and section 6 also has been amended. Why? Because I'm not against women, sir. I'm a full supporter of women, but sometimes what happens is, I could tell you by experience, I think Mr. Nageswara can tell you, that only the son-in-law comes to you for drafting a case. The wife does not come. Why? Because after this, and especially after the amendment of the Hindu Succession Act in 2005, where 29A has been introduced, there they say the rights of a woman is absolute. As soon as a woman is born, a female child is born, it gets a vested right as far as the property is concerned. And Vimal Kumar's case, the Supreme Court was asked to decide whether the act is prospective or retrospective. But the Supreme Court, the lordships of the Supreme Court said, the act is also retrospective, it's also prospective. Why? Because when we had the composite Andhra Pradesh state, most of you are aware, the celluloid hero, Lord Ram and Krishna, that is N.T. Ramarao, introduced an amendment to Hindu Succession Act, whereby introduced section 8A, whereby they say a woman who is married after 28th February in 1985 is alone entitled for a share in the ancestral property. As a matter of right, once she gets married, she does not get any right. But the central government said, this is within our legislative ambit. How could you pass such a law? the central government passed a law by introducing 29A by saying that a female child, as soon as it is born, it is equal to a male child and it gets equal rights in respect of the property, provided the property is not at partition or the rights have not been extinguished by a decree. So a woman today gets equal rights as far as ancestral property is also concerned, and self-acquired. Self-acquired, there's no doubt at all, because Section 8 says a girl child also is supposed to be a class 1 heir. And Vimal Kumar's case, it is 2020 Supreme Court, it says the act is not only prospective, but it's also retrospective. As soon as a child is born, female child is born, she's equal to a male child. That is what is called gender justice. And that is the reason today we have 33% reservation for women in all posts. So the question is, I think mostly in your Andhra area also, most of the posts are infested with lady. Of course, I'm not saying infested, they're not worms and all. Infested with lady judges. The question is, equal. And of course, one thing which is a distant dream is women being given representation in parliament and legislatures. That has been a stillborn child. Why? Because of political opposition. Even the 33% reservation, they want reservation within reservation. Scheduled caste woman, scheduled tribe woman, backward class woman. Then again, A, B, C, and D or a Z work. That's one of the election plans today in the election. So the question is, here, there must be a prima facie case. On the face of it, you must have a triable case on facts and documents. Second one is, you must have the balance of convenience in your favor. And third one is, you will suffer great hardship in case injunction is not granted. In partition suits, most of our advocates, what we do is, we ask for an injunction also, directing the man to direct the defendants not to alienate or charge the property during the pendency of the suit. Please remember, no one wants to have an unwanted child. They will try to alienate the property, charge the property, sell the property so that the other side does not get any right over the property. That's the reason why we take an injunction not to alienate the property pending the disposal of the suit. This can also arise in the case of a specific performance suit where you want the defendant not to alienate the property during the pendency. So injunction everywhere we find. Injunction is a common remedy which has permeated itself into every sphere of activity as far as the civil litigation is concerned. So injunction, the thorough knowledge of injunction, a civil advocate is normally prosperous and makes more money over that. But here injunction is prima facie case, balance of convenience, and relative hardship. Three ingredients will have to be satisfied for grant of injunction. The earliest case decided on this aspect was AR 1963, so 1963 AP 365. That is judgment rendered by Chief Justice Chandra Reddy and Sesha Chalapati. After that, Supreme Court cases also has come, whereby they reiterated the principles laid down in Section 38. So, again, the next type of injunction that is provided is mandatory injunction. That is Section 38, which says mandatory. I think the word mandatory, try to understand. Mandatory, the word mandatory comes from the word mandate. Mandate means command. What you have not done, please do it. You file a suit for injunction. Let's just put it this way. Let us say, even after injunction is granted, the other side constructs on that particular property. Then you want the court to give a mandatory injunction, whereby directing the other side to pull down the offending structures, which affects your right of air, sanitation, ventilation, or your easementary rights. And that is what is called mandatory injunction. Please, this is a precaution which every advocate has to take. Normally, please remember, we try to overcome a decree under some pretext or the other. Suppose this is done, you must amend your claim and ask for mandatory injunction, and the court will direct the other side to remove the offending structures and put it back in the original position. So this is, then we go to copyrights and patents, so on and so forth. Most of you are aware there was an author called Edrupuri Sulochana. I think there was a Telugu film called Gorintaku. In that Gorintaku, the Telugu film Gorintaku is nothing but a reproduction of the novel published by Edrupuri Sulochana. And she brought an action against the producers of Gorintaku to say that they have not taken her permission because she has obtained a copyright as far as that particular novel is concerned, and this has been reproduced by so-and-so. please ask them to pay the damages. Ultimately, it was settled out of court. It was settled. It did not see the light of the day. Then we come across. Please remember. Then next one was one common instance was, there is a classic book on contracts called Law of Contracts by Venkatesh Iyer. It's a classic as far as contracts is concerned. But one Justice E.V. Venkatesham, who was a presiding officer of the High Court here in Andhra, opposite Andhra, copied the entire book, but he changed the name by saying elements of contract. But same so-and-so to so-and-so, the same sections, same commentary, so on and so forth. Ultimately, the executors of Venkatesh Iyer brought an action against Justice Venkatesham for infringement of copyrights. Ultimately, it was settled out of court, money was paid and matter was settled. And nowadays, I think it's become a fashion also. Most of the novelists are going for filing suits, saying that their novels have been copied and made into film. I think there was controversy regarding Srimantudu also, that was copied from some novel and a film was taken on that. So the question is, these instances definitely take place, but the relief is, and sometimes you got what is called, I think some of us were addicted to drinks. There are some famous brands like Teachers, then Royal Stag, Blender Sprite, so on and so forth. But when we go in the night to a shop, Blender Sprite has been spelled as Slender Sprite. Same label, same bottle, same design, same cart, same so on and so forth. In every way it has copied. When you go to that is, వాడు ఎవడైతే లిక్కర్కి పోతాడో వాడికి కళ్ళు కనబడదంట. ఎప్పుడు అది వస్తున్నా చేతిగానే చూస్తుంటాడు. You buy that. But please remember what happens is these products, spurious products which come into the market, spoil and tarnish the reputation of the original holder. So they can always bring an action preventing you from copying it and trying to market it in the market. So that there also injunction can be granted, damages also can be granted. So you don't be under the impression that injunction can be granted only in civil matters, even in copyrights, patents, as well as so in so many matters, injunction can be granted. But the cardinal principles are prima facie case, balance of convenience, and relative hardship. If three ingredients are satisfied, court can grant an injunction, stop that particular thing. Here, please remember, a lot of spurious products are also coming into the market. They market it in such a way that it is the original product of the old company which has got a reputation. Then suppose the person comes to know about it, they seize the bottles. And this has also, I think in your Andhra area, it has also occurred regarding the vithanal, that is seeds. Seeds are also with spurious seeds come, where they try to copy the design of the other side and then try to market it. You can prevent that from happening because your reputation is going to be tarnished. In all these cases, suit for injunction would lie under this specific rule. I mean, making myself clear to you, please. Yes? Then we go into the negative aspect. That is, what are the instances where an injunction cannot be granted? Section 41, that's almost the penultimate section of the Specific Relief Act. There are 10 instances where injunction cannot be granted. One is restraint of judicial proceeding. Suppose, let us say, the other side has obtained a promissory note from you. You are indebted to him. You are bound to pay the money to him. You are a debtor and he is your creditor. You cannot file a suit. Sir, please restrain the other side from filing a suit against me based on the promissory note. You cannot restrain a person from filing a suit. Please remember, it's a free country. You can file a suit anywhere you like against anyone you like, provided you got a right. But such a proceeding cannot be restrained by asking for injunction. No injunction will be granted as far as restraining a person from filing a suit. Second one is restraining a person from filing a criminal proceeding against you. No injunction can be granted which restrains a person from initiating criminal action. If that was the case, now Kavita's case is there, ED and CBI. Kavita cannot file a suit for injunction and say, look, ED and CBI should not arrest me. They should not initiate any proceedings against me under the PMLA Act. The question is, this is against the law. Such an injunction cannot be granted. Then third one is, see, it's the right of every person to offer himself for election, isn't it? You can appear, you can You can offer yourself for an MLA's post, MLA, MP, corporator, MPTC, ZTPC, this PC, that PC, and all. There, you cannot stop anyone from filing his nomination unless and until he is convicted by a criminal court for moral turpitude for more than 7 years. Supreme Court has gone on record to say if it is less than 7 years, there is no bar for him for offering himself for election. One more thing is also there. Mostly, I think most of you know, when you file your nomination, you are supposed to file an affidavit regarding your assets and liabilities. And most of the people get caught there. You say on the day when you became a politician, your assets was only 14 crores. By the time you became an MLA, it became 50 crores. Now today, your assets are to the extent of 300 crores. But you do not mention all these things. You give a false affidavit, or you give an affidavit saying that you are a scheduled caste, or you're a scheduled tribe, or you're a backward class, and offer yourself for election in a reserved seat. Suppose it is detected, your election can be set aside, but the returning officer has got the discretion to reject your nomination also. But you cannot prevent that person from offering himself for an elective post. No injunction can be granted to say you cannot contest elections. Fourth one is a judicial question prosecuting any in court not. Here, suppose let us say, suppose a claim is pending before a district court. You cannot ask for injunction in the lower court and say, please keep the proceeding, the superior court restrained not to proceed with the matter. Such an order cannot be passed. Then to prevent breach of contract, which cannot be enforced. Here, there are certain instances, for example, I told you that suppose there is an agreement to purchase a bar, or let us say at the time when the contract is made, it was perfectly lawful. Subsequently, because of the prohibition policy introduced by the government, such a trade cannot be done. It becomes unlawful. You cannot ask. You cannot ask. That cannot be enforced. So there cannot be an injunction restraining the other side from not selling the property. Then to prevent on the ground of nuisance, which please remember, nuisance is mostly the present day nuisance is the noise pollution which takes place, especially during Bonalu, Batkama Pandaga. Then even now Ramzan and Bakrid also started. They are also playing loud instruments. Please remember, your ears can take only certain decibels of sound. It exceeds that, please remember, your eardrums will burst. Noise pollution is the biggest enemy today. Or let us say nuisance, which has that is to prevent ground of nuisance, which is ground of nuisance is sometimes what happens is nuisance is created everywhere. Let us say nowadays, but nuisance, please remember, we have developed that habit of bearing with all the nuisances now. Suppose there is a marriage, people cannot afford to perform marriages in convention halls and marriage halls. Inti munde oka tent vesestaru, right from the end till the corner. No one can go, no one can come. Dani mundu vehicles kuda bettestaru. Then nuisance is there, but please remember, you cannot take an injunction regarding that unless you are able to establish that the nuisance of such a type where the entire community is affected. Then continuing breach where the plaintiff acquiesced. What do you mean by acquiesced? Acquiesced means where you yourself encourage the other side to commit a breach. But you had something like kettle calling the pot black. You are yourself the violator. You have yourself kept quiet like a Sadhu Maharaj. And tomorrow you cannot say, sir, the other side is the violator. Please injunct him or restrain him from committing that. Injunction cannot be granted. Then when alternative relief is available, alternative relief, please remember, even I think most of you are practicing the High Court also know, in the writ petition you are supposed to write, there is no other alternative and efficacious remedy except filing the writ petition before this Honorable High Court. That para has to be written. Here also, you don't have any other remedy except filing a suit for injunction that you have to satisfy the court. Then your conduct is not above blame. That is, you are yourself the violator. You cannot complain saying that the other side has committed a breach of contract. Then last one is where plaintiff has a personal interest, a negative agreement can be granted. Here, I'll cite one case. I think most of you have been law students. know that in one of the, it's called the opera case, where what happened, there was a contract with a person, with a lady singer, an opera singer, to perform at a particular theater for 2 weeks. She was under a contracted period. And there also a negative clause saying that during the contracted period, she shall not accept any other contract or perform in any other theater. Here, the court was asked to decide whether both of them can, both the matters can be tried together. What the court said is, we cannot enforce the positive aspect, compel her to perform in your theater, but we can prevent it that she cannot perform in any other theater during the contracted period. I think this is the rule in cricket also. There are people who are contracted. That is A group, B group, C group, and D group. They all come under the ICI, they are BCCI. During the contracted period, they cannot accept any other job or any other to play in any other country without the permission of the BCCI. That negative clause also is there. So the negative agreement, negative clause can be implemented, but in very rare and rarest of cases. This is what the scope of the specific relief act is. As far as the next aspect is concerned, any questions, please? Yes.
Sir.
Yes.
Vanakkam, sir.
Vanakkam, sir.
Thank you, sir. Thank you for your. Yes,
yes.
Jacob from High Court as well as Second Secretariat. I met you a couple of times, sir, recently.
Yeah, everyone meets me. Mostly ladies meet me more than gents.
Anyway,
tell me.
Along with Sri Ramlu and Purushottam, we discussed one matter also.
Yes, I remember, sir.
Yes, sir. You are going to Vijayawada then.
Yes.
Recollect. Now, sir, you have cited my own example of amending the plaint. So my decree is 1994, sir. Decree 89 was the case of injunction, permanent injunction was granted in 1994. Now, when I try to refer and understand, amending the plaint is a big challenge.
Now we cannot amend once the suit is disposed of.
That's what, sir. Yes.
Now you have to file a fresh suit, fresh cause of action.
Fresh cause of action of bringing mandatory injunction.
After the decree, whatever has happened, you must file a fresh suit.
Fresh suit in what way, sir?
Cause of action. Based on the fresh cause of action.
Sir, cause of action is disobedience of the decree.
Disobedience. Yes.
Yeah. Disobedience of the decree. The decreed passage is being obstructed again. There is no ingress and egress to the passage, to the house, as well as the lands of the plaintiff.
Now you do one thing, you file a suit for mandate injunction, ask those particular offending structures to be removed.
That yesterday you told me, sir.
Yeah, base your case on the findings in that your earlier injunction suit, and in spite of that, they have done it. Please ask them to remove the offending structures.
True, sir. In the EA, I will ask. Already EP has been filed, sir.
Sir, you cannot ask it now, sir. I'm sorry. Because the suit is disposed of, you cannot ask for a new relief which was not found in the original decree.
There is no relief, new relief, sir. EP is filed. EP, execution petition is filed in
under order 21 to 32. Yes.
39 and 2A.
That is for disobedience.
Yes, that's what. 39 and 2A. Now, disobedience is continuing with the ongoing construction. Now,
sir,
yes, sir.
Your decree is not for removing the construction, sir. I'm sorry to say, only restraining the opposite side from interfering with your possession, isn't it?
Exactly. But
so now
a new decree, sir, decree content.
Mr. Jacob, I'm not disputing a decree, sir. Now what I'm trying to tell you is the structures have come up, or still the constructions are going on, and your order 39 rule A 2A will not give you any relief unless you file a fresh suit.
Fresh suit on what?
Based on the subsequent events which have taken place.
Fresh suit?
Fresh suit for mandatory injunction. Mandatory injunction.
Okay, sir.
Under section 38. Yeah.
Yeah, yes. I got it. Sir, Now,
Yeah,
the decree itself is saying this passage leads to the plaintiff's land.
right.
Okay. Then
Yes,
in 1994, there was no question, or the lands of the plaintiff were not at stake. Now,
right.
having fabricated the pahanis behind the back, he is trying to sell the properties or sold part of it, showing the fabricated pahanis.
Right.
Now, the plaint of this injunction, which was decreed in 94, does not ask for any title of the lands of the plaintiff, which this passage leads to.
Right.
So now that these lands are encroached, these lands are sold with behind the back with fabricated pahanis. What is the recourse? Can I add some prayer or some prayer in the same mandatory injunction, fresh
You must
file?
ask for you must ask for you are not a party to it, so you must ask for a declaration that these things have been done, to declare them as null and void, and also ask for mandatory injunction to remove the offending structures.
In the same mandatory injunction suit, I can.
Same for declaration also.
Yes, sir. Thank you very much, sir.
Welcome. Yes. Yes. Any questions, please? Mr. Ravindra Babu.
Sir, good evening, sir.
Good evening.
Good evening. Good evening to all landed friends and Yajna ordinarians. Sir, in a suit for specific cancellation of settlement deed, can we seek a consequential relief of cancellation of settlement deed along with the declaration of title?
Sir, very fact that you're saying you're asking for declaration of title itself shows that you're not in possession, right? You are not in possession.
I am in possession.
If you are in possession, you'll have to say confirmation of your possession in that suit. When you ask for declaration of title, you must say confirmation of your possession also. And also an injunction for what?
Injunction and also all reliefs along with the cancellation of settlement deed. The plaintiff also sought other reliefs of injunction and not to alienate. Relief of not to alienate.
You cannot ask for cancellation unless you are a party to the document. You can only ask for a declaration of 34 and 35.
I am a lady, old lady, uneducated, illiterate. I cannot read and write, even Telugu also. I executed a settlement deed in favor of my daughter, alleged to be executed, but everything is proved. Recitals in the agreement not intended to be acted upon. Everything is proved. Only thing is on technical grounds that the prayer for cancellation of settlement deed is not as a main prayer. That was reversed by the appellate court.
Okay.
Now the case is before High Court in a second appeal.
Yeah.
That relief of cancellation of settlement deed should be as a main relief, not as a declaration of title. Declaration of title is a main relief, paid court fee, declaration of title only.
Right.
Is there any defect on the part of the lower court, mistake on the part of the lower court advocate seeking as a consequential relief of cancellation of settlement deed?
See, sir, the question is, even now in the High Court, the second appeal, you can amend your plea asking for the consequential relief which has been omitted.
Yeah, we can seek for amendment of
amendment of your plea, right?
As a main prayer of cancellation of settlement deed.
That's only a relief open to you.
That is only relief. Okay. Okay. Thank you, sir. Thank you. Thank you very much.
You're welcome. Yes, miss. Cheppandi Nageshwara garu.
As a matter of fact, when he is not party to the document, as of right, he is not entitled for the relief of cancellation of the document.
Right, right.
not simply, it is not because that it may not be necessary. My friend is feeling that whether the lower court advocate has committed any mistake in seeking that consequential relief. Consequential relief, what have been asked that the settlement is not binding on him.
Yes. Go ahead.
Because where a instrument has been. Hello.
Sir, in this regard, I would request you to kindly go to 2005 ALT 806, judgment of Justice Gopal Krishna Tamara, which says when you are not a party to a document, you cannot ask for cancellation, but you have to ask for declaration.
I am party to the document, sir. I am
If
party
you are
to
a
the
party, you
document.
can definitely ask for cancellation.
Cancellation as a consequential prayer.
What is the main relief? Main relief.
Main relief is declaration of title.
Declaration of title. And you are not in possession now.
I am in position. The suit was declared injunction also.
Decreed. Now in appeal, is it?
Now in appeal, second appeal was reversed based on this technical ground.
Okay.
Only on the sole ground, the entire decree was
Not asked
set
as a
aside.
main, not asked as a main relief.
Main relief. That was the technical objection.
One thing, sir, if the very settlement date creates some interest or right to some other.
Actually, that settlement days was not acted upon. Not acted upon. No acceptance. No acceptance. We are in.
Mr. Nagendra, I request you to look into Section 6 of the Court Fees Act. Section 6 of the Court Fees Act, which speaks about multifarious suits.
That is reference to work fee. But whether he is only beneficiary, some other beneficiaries in the document, that is
Your tone is not audible.
Voice is not clear, sir.
Yeah.
Nageswara garu, voice is not clear.
No, I am unmuted already. But one thing, other beneficiaries are there in the same document. Then the restraint is only for part of, you cannot disturb the equity between them. Because you already made that the settlement is not binding on you. And you already made that you have to get your right declared.
సార్ మీ వాయిస్ రావట్లేదు మీ వాయిస్ రావట్లేదు మీ బ్యాటరీలో ఉంది
Sir,
యువర్ ఇన్స్ట్రుమెంట్ బ్యాటరీలో సార్
sir, another aspect
గారు మీ ఇన్స్ట్రుమెంట్ బ్యాటరీలో
of instrument. Executed can only seek a cancellation of an instrument. And limitation is 3 years. But as in the case of
58 and 59 article.
Yeah, as in the case of the Section 17 Limitation Act, the protect measure is given to the victims. So, can you update on that, sir?
Now, what is the position of the case now?
In this also, we came to the knowledge of the fraud document was alleged to have been executed.
Right.
After filing the suit by the one of the donee for injunction against my sons,
Okay.
So that was the knowledge of the fraud attributed.
Right.
That 17 also discussed elaborately in this suit. The date of the knowledge of the fraud.
Right.
Date of the knowledge. And also another aspect was burden of proof. The person who initial burden is on the plaintiff. Because she is the old lady, uneducated, illiterate lady. So that's why the burden, after initial burden, the burden shifts to the defendant. Supreme Court, as per Supreme Court ruling.
And burden of proof chapter.
Yes, sir. That was also in our favor, in view of the Supreme Court order. The only point for consideration by the appellate court is the technical aspect. Because it is a consequential relief of, not as a main relief, that's what this entire judgment and decree was reversed. Yes, sir. That is the point only.
Now it's in second appeal, is it?
It is second appeal, part heard. It is a matter is a part heard. Judge.
Now in second appeal, you can, sir, second appeal, as a substantial question of law, you can say, what is the
Yeah.
effect of a consequential relief not being claimed as a main relief? What is the legal interpretation for that? You ask for an interpretation as far as your consequential relief is concerned.
Yeah, that is
Whether
only
you want
point.
to- Yeah,
That is-
you raise it by way of a substantial question of law.
That already raised, sir. All points raised in the second appeal considered by the learned judge.
Audio
The
unmute
point
లో
on which the technical ground. The
No, you
technical
take
ground.
the technical ground, you take it as a substantial ground of law.
But
Let the court interpret it.
But the court fee also insufficient. But if it is a main prayer, we need to pay the court fee for cancellation of the instrument.
Right, I value of the document.
Value of the document. That was
It's a curable defect, sir. It's not incurable.
even the amendment also it is not possible, I think.
No,
Is
because
it-
order 6 rule 17(2) is there. Once issues are framed and the evidence affidavits are filed, amendment cannot be allowed as a matter of right. They
Yeah, that
introduced
is-
by the Amendment Act of 2002.
that is the reason I have not made any attempt. సార్ మిమ్మల్ని నేను చూసి చాలా రోజులు అయింది సార్. మిమ్మల్ని
Sir.
సికింద్రాబాద్ కోర్టులో ఎప్పుడు చూస్తుంటున్నాను సార్. ఎప్పుడంటే
Sir.
హైకోర్టు అక్కడ జరిగింది మీకు గుర్తుందా సార్?
అవును సార్.
హైకోర్టు వాజ్ షిఫ్టెడ్ టు సికింద్రాబాద్ కోర్ట్స్.
రైట్ సార్.
డ్యూరింగ్ ద కర్ఫ్యూ పీరియడ్. చెన్నారెడ్డి టైం.
ఎగ్జాక్ట్లీ సార్.
అప్పుడు నుంచి మీరు నాకు రెగ్యులర్ అప్పుడు సికింద్రాబాద్ కోర్టు థర్డ్ అడిషనల్ కోర్టులో నేను సూట్స్ చేశాను సార్. 2-3 సూట్లు. 92, 93 ఆ టైంలో మీరు రెగ్యులర్ గా వచ్చేవారు. సికింద్రాబాద్ కోర్టుకి రెగ్యులర్ గా వచ్చేవారు. ఇంకొక అతను తలపాగా పెట్టుకుంటారు. ఆయన పేరు మర్చిపోయాను సార్. తలపాగా ఆయన పేరు ఏంటో మర్చిపోయాను నేను. బట్ ఐ వాజ్ ఆల్సో అక్వెంటెడ్ విత్ దట్ advocate also, sir. You both
you are practicing where, sir?
Sir, to the point, please.
High Court of AP, sir. High Court of AP.
Sir, నెంబర్ తీసుకొని మీరు పర్సనల్ గా మాట్లాడండి.
Okay.
I think my number is with you. You can pass on my number.
This is Kalyan number.
Yes, sir. Yes, sir.
Kalyan's number is there. You can note down my number also, sir. 8639
3639
86
86
39
yeah
005697
0056
97
56 0056
97.
Madam,
Yes,
today's
sir.
we have finished specific relief act.
Yes, sir.
If you want us to continue next week,
Hello, sir.
I to do the art of cross-examination in civil and criminal matters.
Hello,
Yes.
sir.
And
Hello, sir.
that also the ethics part of it and the behavior of advocates in courts, how we have to address the court, how we have to gain the respect of the bench, how we have to behave, all this court behavior.
Yes, sir.
I think mostly
Hello,
now if I can give you instances where judges are very much angry. They say, sir, post it to 18(4). Then the judge says, are you giving me an order? Say, kindly post it to 18(4). You don't lose anything by saying so. Thank you. These are all basic things, madam. No one taught us when we came to the profession. But these are things which we have to remember. And especially, of course, it's not competent for me. I'm not a bar council member. Also, the dress code, which is prescribed by the bar council, which is not followed. Anyhow, thank you very much.
Hello.
థ్యాంక్ యూ సార్.
Hello.
సార్ వీకెండ్స్ కి తీసుకోండి సార్, ప్రాక్టీస్ ఓరియంటెడ్ సాటర్డే సండేస్.
Hello.
Wait. Sir, someone is asking.
You kind, because madam, I am only doing
Hello.
chamber practice, madam. My colleagues look after my fixtures, something like my assistants. You can
Hello, sir.
correspond with that. I'm always available to you.
Yes, sir.
Hello, sir. Hello.
Thank you. Yes.
Hello.
Yes.
Sir, I am Ravindra.
Thank you,
sir.
from
Thank you,
Gujarat,
sir.
sir.
Thank you so much, sir.
Ravindra
Hello.
Babu garu, mere personal ga kalvan, sir.
Hello, sir.
Thank you. Yes.
Hello.
Thank you, sir. I'm
Hello, sir. Personal
Hello.
Sorry, Rao garu.
ఓకే మేడం.
ఇక్కడ ఏదో కన్ఫ్యూజన్ అయింది. He left.
ఓకే మేడం. ఓకే.
So 2 minutes to talk to you all. And you all know that in the morning hours we have evidence class. And
ఓకే. నేను చూసానండి, మెసేజ్ చూసాను.
And we are planning to conduct IPC as well as CRPC also. And schedules are very tight. And your presence is required in each class. And with regard to some person's behavior, I got some calls. It is like this. We are pooling girls and boys. That means advocates of both female and men. Some male persons are sending messages to female advocates.
Okay.
It's not correct.